I'm Charene Nortier and I am from the Conduct of Business Supervision Division. I'm very pleased to host you for today's webinar. Today we're going to look at some of the recent legislative changes in the FAIS environment. So let's start taking a look at what those changes were. We're going to start with the FSCA FAIS Notice 69 of 2020. The purpose of this exemption notice is to amend the previous exemption notice that allowed category 1.1 and 1.19 FSPs to be exempted from the PI cover requirements. So this exemption has been extended until the 31st of August 2022. We then look at FSCA FAIS Notice 68 of 2020. And this is particularly important for those FSPs who are long-term insurers or short-term insurers, as this exemption then helps them to not have to comply with requirements of Section 13 of the General Code of Conduct. This exemption has been extended until the 31st of August of 2022 as well. Board Notice 706 and 707 of 2020 are two particularly important board notices. The General Code of Conduct was amended and the determination of fit and proper requirements were amended as well. We're not going to be focusing on the amendment of the General Code of Conduct in this session. We are going to have a separate session on that amendment because it is quite a long and involved exemption amendment. And we are going to be focusing in more detail on the amendments of fit and proper. We then have three notices that were published directly as a result of the impact of COVID-19 on the industry. The first of this is FSCA FAIS Notice 21 of 2020, and this exempted the FSPs and juristic representatives from certain financial soundness requirements. This is a very useful notice if you have found the economic impact of the COVID-19 and the lockdown requirements on your business. So if that at all has hit hard and you are very aware of that, take a look at this notice because this could alleviate some of the requirements that you have to normally adhere to. The FSCA FAIS Notice 22 of 2020 did two things. It extended the CPD cycle for 2019/2020 up to the 31st of August of 2020, and it pro rata reduces the CPD hours for the 2020/2021 cycle. We are going to be looking at that again in more detail later in the session. It also changes the due date for supervised representatives who needed to meet the requirements for the regulatory examinations, qualifications and conduct of business training between the 27th of March 2020 and the 30th of November 2020. So the due date for supervised representatives for any of those requirements has been extended to the 15th of December of 2020. Also very important for representatives. And then the last notice that I want to bring to your attention is the FSCA General Notice 2 of 2020. And this extended the submission of financial statements for the period 30 November 2019 up to 30 June 2020 with 4 months. It's also quite a useful extension, we think. So if we now start looking in specifics at fit and proper, then the amendment notice is Board Notice 707 of 2020 and it was published on the 26th of June 2020. A couple of new definitions were added to this board notice. I'm not going to go into detail into those definitions, but I do want to bring it to your attention that the definition of cash, CPD activity, and certain insurance-related definitions were amended or inserted. And what we also then have in Section 47 that deals specifically with financial soundness requirements, there are two additional definitions. So we now have a definition for annual expenditure, and we also have a definition for remuneration. If we start delving into the changes into fit and proper specifically, then one of the big changes was on the honesty and integrity section. And in Section 10, there is a requirement that FSPs and key individuals must disclose information relating to their honesty, integrity and good standing to the authority And a representative has to disclose any of those events or activities that impacts on their honesty, integrity and good standing to the FSP itself. And this is important that people understand that all information that may be relevant to determine the compliance with the requirements of fit and proper must be disclosed, and it must be disclosed voluntarily. So there mustn't be a requirement from the FSP or the FSCA for the person to disclose this. When an event occurs that could have an impact on your standing, you as an individual must disclose it to the relevant authority. In Section 40, the fit and proper determination deals with the appointment of representatives. And in Section 41A, it then says that an FSP must ensure that where it appoints a person as a representative, the person is not an unrehabilitated insolvent. So this is the person who is not yet in your employ. You are considering the employment of that person. And it is then very important to make sure that you make sure that that person meets these requirements before you enter into an employment relationship or a mandatory agreement relationship with this representative. When, however, you already have employed the person and something happened in the person's circumstances, then Section 45, 40 in brackets 5 becomes important. Here it talks about the person who works for you already, and that person is then sequestrated after the appointment took place. Here, the FSP can allow that person to continue to act on its behalf as a representative if the FSP implements appropriate measures to mitigate any risks that may arise for clients or the FSP as a result of the representative being sequestrated. So this is important because this has been an issue that a lot of people have worried about in the past. It wasn't clear in the previous wording as to what happens if the person already works for you. And this amendment now makes it very clear that if the FSP is willing to make certain changes, it can continue with that employment relationship. The employment relationship does not have to be terminated as a result of the sequestration of the person. If we start looking at the changes in terms of CPD, I think it is important that we must first just stop and think what the purpose of CPD is and why we have CPD. Now, the purpose of CPD is threefold. So firstly, it is to maintain the existing knowledge and skills that are appropriate to the activities and responsibilities of affected persons. If we unpack that, it means that if you're a key individual or the sole proprietor or a representative, you have certain skills and knowledge that you require so that you can do your job, so that you can fulfill your role. And it is important that you maintain that. You make sure that your knowledge and your skills are always up to date and that you're able to deal with it as it is relevant and current at that specific point in time. It is also important that you must update your knowledge and skills. If, as a result of COVID, your company has become very virtual based, and in the past you weren't very familiar with virtual applications, then updating your knowledge and skills in terms of virtual applications would have been a perfect opportunity for CPD if you found such a CPD activity. The third thing that is important in terms of CPD and the purpose for that is to acquire new knowledge and skills to assist with your current activities and responsibilities or the functions that you are thinking of performing in the future. So you can also use CPD to skill yourself for the future. The CPD amendment that I mentioned earlier, distinct parts to it. So the first one talks about the 2019/2020 cycle. Now, you will remember that the cycles work from the 1st of June of one year to the 31st of May of the second year. This cycle that would have ended on the 31st of May of 2020 was extended with 3 months. So it came to an end on the 31st of August 2020. So the CPD hours remained exactly the same. They weren't reduced but you were given an additional 3 months. And the purpose of this was that a lot of CPD activities and events that had been planned had to be cancelled as a result of the impact of lockdown. And at the start of the lockdown period in March, none of us knew how long we would be in lockdown and how long we would be at certain levels. So the 3 months were granted as a reasonable period for people to find alternative options to meet their CPD requirements. The 2020/2021 cycle started on the 1st of June, so we had an overlap of 3 months between the previous cycle and the new cycle. And it still ends on the 31st of May of 2021. So the period remained exactly the same. But in acknowledgement of the overlap of 3 months, we've reduced the hours required with the value of 3 months worth of CPD hours. So those of you who normally would need to get 6 hours only have to get 4.5 hours in this current cycle. If you normally have to get 12 hours, it's been reduced to 9 hours. And those of you who normally have to get 18 hours only have to get 13.5 hours. So it is important to make sure that you allocate your CPD hours to the right cycle and that you don't, by mistake, double count your hours. Because the moment you've met your requirements for the previous cycle, you could start getting your requirements for the new cycle. So you can't just rely on the date of your certificate. On your competence register, it is important that you make a note to say that this specific CPD activity or event that you participated in is going to count for which cycle. And it's going to be a problem unique to this specific period. But I do urge you to make sure that you put your notes on your competence registers and that you also make your notes on the individual staff file. That is going to help you in the future because you are going to forget how did you allocate it. And if you don't make notes, it's easy to make a mistake here. If we look at the relevance of CPD, and I have alluded to this already, it is important that people must select CPD activities that helps them with their knowledge, their skill, their expertise, and their professional and ethical standards. What we find is that sometimes people will, in one cycle, obtain a lot of these CPD activities in one of these specific fields. So you could get that in 1 year, the bulk of a person's CPD activities were in the field of professional and ethical standards, and they didn't get a lot of CPD activities around knowledge, skill, expertise, technical knowledge, etc. What I would advise you to do then, if that happened, is that in the next CPD cycle, you look at the gap and you address the gap that you might have in terms of your technical or generic knowledge, or even the context within which the financial services are rendered. It's great if you get a lot of knowledge and development around professional and ethical standards, but you must understand that the CPD environment is much bigger than just that, and you shouldn't get all of your CPD requirements in one part of the field and the plethora of activities. Rather spread it across it and try and get a balanced approach to your CPD hours. We often get asked why and how can class of business training also be recognized for CPD purposes? Because normally class of business training would be done at the start of your career before you need to meet CPD requirements. What we have had in the past, and this is what gave us the acknowledgement that we can allow class of business training as a CPD activity, is the fact that we have people who have been in the industry for a long time, and they were interested in doing class of business training in one of the fields that they already have been functioning in. And as a result of the transitional arrangements with the 2017 changes in fit and proper, did not have to get class of business training again. But they felt that it would be useful and update their skills and knowledge. But because typically this is quite intense training, they wanted this to be recognized for CPD purposes. And because we feel that it is generic in nature and it addresses the fundamental knowledge a person requires to identify a product in that particular class of business, we agreed that this could be recognized for CPD purposes for those people who do not actually have to do class of business training, but they feel that it would enable them to do their job a little bit better with more confidence and knowing that their knowledge and skills are up to date. And we are almost at the end of this presentation. If we look at our last slide, it talks about product-specific training. Now, product-specific training refers to the specific product in respect of which services are rendered that is unique to that particular product supplier. And it includes product amendments. Now, what is very interesting about product-specific training is that it can be provided by any person. So it can be provided by a product house, a product supplier. It can be provided by a training specialist, and it can be provided by the FSP itself. The proviso is that it must be based on the most recent and relevant changes or amendments to existing products, or if it is a brand new product, the information about that brand new product that is being launched to the market. You must also remember that you cannot provide any advice or intermediary services on a product if there have been significant changes to that product and you have not undergone product-specific training. And it is the FSP's responsibility to make sure that the key individuals, the representatives, or if it's a sole proprietor, the FSP itself has that knowledge before they engage a client about that specific training. And that specific, without the specific training, you can't engage the clients about the products. Again, if you look at your competence register, I would advise that you have a competence register that has two parts to it. That one part of it records the date of the training, who provided the training, who attended the training, you know, the normal sort of overview information of the training that was provided. The second part of the competence register must have provision that you can record the content of the training that was attended by the people. This is going to be very helpful if you get complaints or queries in the future and you have to go and check, did the person who gave the advice or provided the intermediary service have the right information and knowledge when they gave that information or provided the service to the client? And that is where your two-part competence register is going to be useful, because the one part is going to give you the date and the overall detail of what was attended and who attended it when and who provided it. And the second part is going to give you the content of what the person was trained on. And that will assist you to give clients or the ombud, whoever queried you at that stage, the detailed information that they may require. So this talks about the record keeping requirements, that is quite significant and important. In the future, FSPs may also be required to provide confirmation of such training to the FSCA. So it's also important that you have that information available so that when you are queried, you are able to provide such information to us. I hope that this session, where we looked at some of the more significant pieces of legislation that has been published in the last 6 months, has been a helpful overview. We will have a second session where we are going to be concentrating specifically on the General Code of Conduct, and I hope that everyone will be able to also attend that session. Thank you so much for your time and attention. All the best.